Oh, yes. What's your view of introducing cameras into the
Harder
courtroom?
question. Harder question. The cameras, the problem with the cameras in the, I mean, people are pretty familiar with the reasons for doing it. I mean, people would see the oral argument. And when there's a case like, which I thought was a great case, the question, for many reasons, the question of the constitutionality of an Arkansas law that limited the number of terms to 2, or 6 maybe, I don't remember the number, that a representative, it was term limits for the members of Congress. And that was such an important or good case for teaching purposes, going back to being a professor, because my goodness, it was evenly balanced. I mean, if you look at the language of the Constitution, it says that the qualifications are that you be 25 years old, you have to be a citizen of the United States and a citizen of the state where you're being elected from. It doesn't say whether those are only qualifications or exclusive, or whether you could have others. And then if you think, well, couldn't they say you can't be mentally ill? Sure they should. Well, could they then say you have to be a property owner? Not so easy. What did Jefferson think? He thought one thing. Story thought one thing. Madison and Hamilton thought the opposite. They actually expressed themselves on the meaning of that in opposite directions. You look at the precedent. It goes in different directions. Everything seemed very evenly balanced, and people could have seen the argument in that case. They would have seen 9 judges who are really trying to work this thing out. They're doing what they're supposed to be doing, and it was hard. We ended up being 5-4, saying it was unconstitutional, but it was a close question, and many are like that. And you could get that out to the public; they would see that more, and they would be less suspicious. So why not? Well, there are a number of reasons, for better or for worse. One of them is, what about the criminal cases? So if you're not a criminal court, you're an appellate court. Yes, but we're a symbol. We're a symbol. And if we had it in the Supreme Court, would it be in every case in the country? I don't know. I say we don't know. It might. What about the jurors? What about the witnesses, etc.? I mean, that's not us, we know, but we're still a symbol. Well, would people understand that this is only 5% of the case, the oral argument? 95% is in writing. Maybe they wouldn't. I don't know if that's so important. But people do relate to people. So when you see something, you relate to that person, one or the other. And we are making decisions for millions who are not in the room. Very tempting to be for this lawyer, that's the good one, that's the bad one. Or when you're shown the picture of the client, that's the good one, that's the bad one. It's not for them. It really, at the Supreme Court, more than in an appellate court. Appellate court, you have sort of things going both ways, the general and the specific. The Supreme Court, it is the general rule. Always the general, virtually always. And those people aren't there. And the public would not know that, or have a hard time explaining it. It's often not explained even in the press, and it depends, etc. But then, is there, I mean, one of my colleagues said to me, I won't say which one, he had a good sense of humor, this one, we have our picture taken when we have a new member. And now what they're doing in the Post, they do this, they show the picture, but they show the curtain so it looks ridiculous. So what he said is they have a good one of you and a bad one, and when you write a decision that you like, they put in the good one, and they write the decision you don't like, they put in the bad one. All right, so that's a joke, but nonetheless, what about the sound bites, etc.? I mean, we see ourselves as trustees. We didn't create this institution. We're there despite what seems like a long term for a pretty short time in the history of the country. And we don't want to leave that institution in worse shape than we found it. I mean, that's the last thing anyone wants. And there's no going back. And so who knows, you see. So what you're seeing are people, all of whom are pretty conservative in this area, being rather uncertain about what kind of door they're opening. And you can talk all the theory you want, but unless you make these people secure, they're not going to open that door. And I think, that's why I think, you know, you really could find out a lot of stuff. I mean, I know there is such a thing called good social science research, and there are a lot of places. Canada, for example, has it. The world doesn't come to an end. A lot of states have it. They did have it, then they did, they didn't, then they did. I think we could learn a lot. But that, and that whoever does this should not be paid by the networks. In other words, they should, objective studies find out, try to figure out what it does to attitudes and so forth. So I suppose eventually it will come, but it's not, I don't think the court's ready for it yet.
You stress the importance of the informed populace and furthering civic education. How can we law students contribute to that effort?
You do it. You have to, although you're law students, you have to learn the law. So they have a variety of ways of making that somewhat entertaining some of the time, and not always. But you have to learn the law. You go out and you learn a lot of things. You practice law. It's not so hard as the law student to participate in some other activities. What's hard is when you get into practice. What's hard is when you don't have the time. What's hard is when you have the family and you're trying to earn a paycheck and you have other things on your mind. And what is hard is even then to say, I could go and spend 2 hours on law day even, talking to a high school class about what I do, or working on a bar committee, or getting that bar committee and getting other members of the bar to talk to an editorial board about getting some of these editorial boards an understanding of what courts are like and why maybe somebody made an unpopular decision, about sort of spreading the word in 1,000 different ways through teaching, through bringing, in Boston, I'm sure they do here, a lot of courts have classes come in from high school and look at arguments and have moot courts. And the bar can do a lot, and lawyers are members of the bar, and they even have sections for students. And there is a lot that can be done by way of participation that helps other people understand what it is that lawyers are here for, and judges and courts.
Why are you so confident that the more people know about the court, the more they will respect the court? Increased transparency hasn't done much to stem increasing skepticism toward the other two branches of government. Yeah.
The answer is it's just the way I'm made. I mean, I think there are two. There is a group, there are people who quite in good faith and may well be right say keep everything mysterious. And the European courts, a lot of them, they say they should be unanimous. They hide the dissent because they think it will have more effectiveness to be unanimous. And I say, well, I don't know that'll work in today's day and age. I think it's better to be transparent. That doesn't mean I'm necessarily going to televise the oral argument, but I mean, tell people what you do. I think it's just, I have some confidence in that. I think if that doesn't work, I don't know what will. And you're not going to run a society by keeping things mysterious. And the answer to this mysterious thing is tell them what you do and say, if you don't like what's going on, participate and make it better. And that I think is the bet we've made. And we've been making that bet for a long time, so I can't prove it.
What are the pros and cons of textualism in statutory interpretation?
Well, I said a little bit about that. I think all judges really have 6 tools that they use when they get to these statutes. They can't figure out what anybody's talking about. 1 is the text, you read the words. 2 is the history, what went on when this was written. 3 is the tradition. If it says habeas corpus, those words have a tradition around it. 4 is the precedent, which usually is in both directions. 5 is the purposes. Somebody wrote those words. I say, let's find out who wrote them and what they had in mind. And 6 are the consequences. And the consequences mean not any old consequence, but if you further the purpose more, there going to be consequences. Does that further or hinder the purpose more? Now, everybody has those 6 tools. The textualists think that they can and decide the case by relying on the first 4, by looking at the text, by looking at the history, by looking at the tradition, by looking at the precedent. And I tend to think it's the last 2 that matter the most. I don't deny the first 4, and sometimes they're very good at answering a case, and they don't deny the last 2, though Justice Scalia did once say, I don't think I ever have to look to purposes. And I said, I have an article here that you wrote where you said you did. So he says, So he said, well, I mean, not all that often. And I think that is the key to it, I think. And I think that the textualists believe that, as I said before, same with the originalism, they will control the subjective impulses of the judge. And I say, I don't think you will. I think you'll hide the ball. I think that it's better to look to see what you get words like any law enforcement officer. Does that include a prison official? It says any, doesn't it? I say, oh yeah, it says any. Great, wonderful. I say, there isn't any butter in the fridge. Okay? There isn't any butter. That's my wife says. Does that mean there's no butter in the city? No, it means there's no butter in the fridge. Okay, did it say in the fridge? No, it didn't say in the fridge. All right. So you're always having to look to context. And I said, let's look to it overtly. Let's find out what they were after. Well, that's my side of it. And the other side is, this is too risky. You will unleash the judge's subjective influence. All right, so the argument goes on.
How do you prepare for oral argument? Do you think oral argument makes a difference? Does it ever change your mind? Does it ever change anyone else's mind?
Yes, yes, yes is the last. I think if you mean by change, actually, you were going to go affirm and then reverse. I'd say not too often. If you tell me less than 5%, that's too low. If you say more than 15%, I think that's too high. If you say change the way you look at the case, a lot, 20, 30%, a lot. And that matters, because it's how you're going to write this, and the law clerks don't necessarily see that. The way I prepare for a case is, all right, we have 12 cases that are going to start on the 2nd or 3rd of October, the next 2 weeks. I've just finished reading the 12 sets of briefs. I will read the briefs. I don't read all the cert petitions. I read memos, and I glance at them, but I do read all the briefs. And so I read through them, and I write incomprehensible notes on the back. And I send them back to my law clerks. I say, there are 4 of you, there's 1 of me, so you should know this case 3 times better. And then we'll have a conversation. Since it's the summer, we've had it on the phone. And I've talked to each of them about the 12 cases, and we discussed it. I said, I want you to write a memo, and I want the memo to be about, include this or that. Don't waste time. I mean, I know part of this anyway fairly well. Or I might say that, my God, I can't believe this case. You're going to have to really look into this. And you write the memo as you want it, but be sure you answer my questions. So then, before I go into the oral argument, I will have read that memo, and I've had another conversation with the clerks. So most of the time, I've had 2 conversations and a memo, and I've read the brief. So I feel I'm fairly well prepared. And all my colleagues have some system. And that includes the amicus briefs, which sometimes are very valuable. Now, I don't guarantee I pay the same attention if there are 40 amicus briefs. But what I'll do then is I order them in my own secret way. And I will then start reading the amicus, and then pretty soon they begin to become repetitive. I'll read that table of contents, see if it has anything new in it. Or I might thumb through it pretty quickly, but there won't be any I don't at least pick up and look at that table of contents. And so I feel I'm fairly well prepared. And then the question period is really for us, the judges. I mean, we're trying to ask questions that we think the lawyer will be able to help us with the answer. He'll be able to answer the question. It makes a difference to the case. And then we'll get some help. Now, some of my colleagues think that's the null set. but yeah, I think you sometimes get pretty good answers, and sometimes you get something going, and sometimes you don't. So that's the system.